Who speaks for the people? Is it Parliament, made up of men and women elected by the millions, carrying the weight of the ballot box? Or is it the judiciary, a handful of unelected judges sworn not to the crowd but to the constitution, standing guard even when the people themselves forget? This question has stalked India from the very birth of our republic. It is not an abstract academic puzzle. It is the living struggle that has shaped our democracy in every crisis, from the land reforms of 1950s to the emergency of 1975 to the striking down of the NJAC in 2015. Granville Austin, the historian of our constitution, once said, "The Indian constitution is a seamless web of three institutions: the legislature, the executive, and the judiciary, each designed to cooperate, yet destined to conflict." And Dr. B.R. Ambedkar warned in the Constituent Assembly, "The judiciary must be independent of the executive, but the judiciary must also be independent of the legislature. Otherwise, there is no meaning to the constitution." Tonight, in this constitutional dialogue, we do not gather as cheerleaders of either side. We gather as citizens to ask, in a democracy like India, where sovereignty belongs to the people, who truly carries their voice? Is it the representative in parliament or the judges on the bench? Or perhaps neither, but the constitution itself standing above both? This is the trial we open today: Parliament versus Judiciary. Who speaks for the people? Let us begin. When the Constituent Assembly sat between 1946 and 1949, this very question haunted every debate. On the one hand, leaders like Jawaharlal Nehru believed Parliament embodied the destiny of the nation. In his words, Parliament is the temple of democracy. It represents the will of the people in its highest form. On the other hand, Ambedkar, Adadi Krishnaswamy Iyer, and K.M. Munshi insisted that unchecked parliamentary power would be dangerous. Ambedkar said with characteristic bluntness, Parliament is supreme in matters of lawmaking, but it is not supreme in matters of the constitution. This tension was deliberately written into our constitution. Article 13 declared that any law inconsistent with fundamental rights would be void. This was direct limitation on Parliament. Article 368, however, gave Parliament the power to amend the constitution itself. But how far could that power go? Could Parliament amend even fundamental rights? Could it change the very identity of the constitution? Ambedkar foresaw this problem. He remarked, "The constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of the age." The founding fathers did not hand us a clear answer. They handed us a living tension: a parliament meant to be powerful but not omnipotent, a judiciary meant to be independent but not supreme. The British model gave Parliament absolute sovereignty. The American model gave the Supreme Court the final word. India's model, a middle path that would soon be tested in battle. Part 2 of this lecture is about the philosophy of power. Let us pause here. History told us how the Constituent Assembly built the scaffolding. But philosophy tells us why the structure still shakes. At its heart, this is not merely a legal contest. It is a philosophical conflict, a conflict between two claims to ultimate legitimacy. On one side, Parliament. It claims rest on numbers, the majority, the ballot box. It says, "We are the people, we are elected, we make the laws, who can question us?" On the other side, the judiciary. Its claim rests on principles, the constitution, the higher law. It says, "We protect the people even from their own representatives if those representatives violate the constitution." So the real question is not just Parliament versus judiciary. It is numbers versus principles. It is majority will versus constitutional morality. Let us examine both sides carefully. In Britain, the doctrine of parliamentary sovereignty reigns supreme. A law passed by Westminster cannot be struck down by any court. The judges may interpret, but they cannot invalidate. As Dicey famously said, Parliament can do everything except make a man or a woman, and a woman a man. But India rejected that model. Why? Because Ambedkar and the framers feared tyranny of majority. They had seen how Hitler rose to power through elections. They had seen how majorities can trample minorities. Ambedkar's words in the assembly remain chilling. Constitutional morality is not a natural sentiment. It has to be cultivated. democracy in India is only a top dressing on an Indian soil, which is essentially undemocratic. In America, the Supreme Court became the guardian. For Marbury versus Madison in 1803, the principle was set. Courts could strike down laws inconsistent with the Constitution. But even in America, this raised unease. Unelected judges, life tenured, overturning the will of elected legislatures. India chose neither extreme. India chose a hybrid. Parliament is not sovereign. Courts are not omnipotent. The Constitution is supreme. But supremacy of Constitution means something subtle. It means there will always be tension. Parliament pushing with the will of the numbers. Judiciary pulling with the restraint of principle. This tension is not flaw. It is the design. Now let us ask, why does the judiciary intervene at all? Here we meet the counter-majoritarian dilemma. The dilemma is this: in a democracy built on majority rule, why should a handful of unelected judges have the power to overturn the laws passed by the majority's representatives? The only answer, the only justification is that the Constitution itself gives judges this role. Article 13 does not just allow judicial review, it demands it. If fundamental rights are not North Star, then judicial review is the compass. But here lies the danger. When does review become rule? When does interpretation become legislation? When does the guardian become the master? Justice Jackson of the US Supreme Court once warned, "We are not final because we are infallible. We are infallible only because we are final." India's judges live with the same paradox. Now think of Parliament. Its claim is equally powerful. Members are elected. They walk into Lok Sabha with the legitimacy of millions of votes. They can say with pride, "We are the true voice of the people." Who gave the judges this authority? No one voted for them. Indira Gandhi once declared in Parliament, Parliament is supreme because it is the embodiment of the will of people. Her words still echo in every clash between elected power and judicial restraint. But if Parliament alone is supreme, what stops it from amending away every right? What stops it from converting democracy into dictatorship by law? This is why the basic doctrine, structure doctrine, emerged to answer the temptation to draw the line, to remind Parliament, you are powerful but not all powerful. Justice H.R. Khanna captured the philosophy in Kesavananda. The Constitution has not created an unlimited power in Parliament to amend the Constitution. If unlimited power had been conferred, it would destroy the foundation on which it rests. So, where does this leave us? We stand between two absolutes. The British absolute, Parliament is sovereign. The American absolute, Supreme Court is sovereign. India's experiment, it says, Constitution is sovereign. But here's the catch. The Constitution cannot speak on its own. It must speak through institutions. And so, its supremacy is always filtered, either through Parliament or through the judiciary. This is the real battlefield, not just law, not just politics, but philosophy itself. Who embodies the people better, the representative with the vote or the judge with the oath? Granville Austin was right. Quote, "The Indian Constitution is a seamless web," unquote. But even a seamless web has knots. This knot between Parliament and judiciary has tightened with every crisis. And now, to understand how this philosophical conflict becomes real, how ideas became battles, we must turn to the great constitutional crisis of our republic. Moments when theory collided with power, moments when the question, who speaks for the people, was answered not in words, but in judgments. Let us now move to those crises. Part 3 is about those crises and clashes. Every great idea in India's constitutional history has not emerged in calm. It has emerged in conflict when Parliament and judiciary collided. Sparks flew, and those sparks lit the path we now walk. Let us walk through these battles, a few of them. Case 1 was Shankari Prasad of 1951. The first clash came soon after independence. Parliament passed the First Amendment to protect land reform laws from being struck down for violating fundamental rights. The question was, can Parliament amend fundamental rights under Article 368? The Supreme Court in Shankari Prasad versus Union of India answered yes. The court said the power to amend the constitution under Article 368 includes the power to amend the fundamental rights. In those words, Parliament was given wide authority. The people's representatives could even rewrite the people's rights. It seemed settled, but not for long. Case 2 is Sajjan Singh of 1965. In Sajjan Singh versus State of Rajasthan, Parliament again amended the constitution to protect its laws. The court again upheld Parliament's power. But here, doubts began to creep in Justice J.R. Mudholkar. In a separate opinion, asked a fateful question: does the constitution not have a basic feature which Parliament cannot touch? That question would soon become destiny. Case 3 is about Golaknath of 1967. Now came the turning point. In IC Golaknath versus State of Punjab, the court reversed itself by a narrow 6-5 majority. It declared that Parliament could not amend fundamental rights at all. Chief Justice Subba Rao wrote, Parliament has no right to or power to amend Part 3 of the Constitution so as to take away or abridge fundamental rights. This was explosive. Suddenly the judiciary stood as an iron wall. Parliament could legislate, but it could not amend away rights. The Parliament's voice was checked. The judiciary's voice thundered. Case 4 is Kesavananda Bharati of 1973. Golaknath created paralysis. Parliament amended. Courts struck down. The system strained. Then came Kesavananda Bharati versus State of Kerala. The case of judges. The case of the cases. A 13-judge bench, the largest in India's history. The judgment ran over 700 pages. The court was split 7-6. But from that narrow split, a doctrine was born. The basic structure doctrine. Chief Justice secretly declared, Parliament's power to amend the Constitution is wide, but it is not limited. It cannot alter the basic structure or framework of the Constitution. Justice H.R. Khanna, the decisive vote said, the power of amendment does not include the power to destroy. Unlimited power is not an unlimited power. The court did not list all the elements of the basic structure, but it named some. Supremacy of the Constitution, rule of law, separation of powers, judicial review, and fundamental rights. In one stroke, the judiciary declared Parliament is powerful, but the Constitution is supreme. This was not just a judgment, it was a revolution. Case 5 is Indira Gandhi versus Raj Narain, 1975. Now, the theory was tested in fire. Prime Minister Indira Gandhi's election was challenged in Allahabad High Court for electoral malpractices. The court invalidated her election. She appealed to the Supreme Court, but before the case concluded, she declared the emergency in June 1975. Parliament quickly passed the 39th Amendment, placing the election of the Prime Minister beyond judicial review. But in Indira Gandhi versus Raj Narain, the Supreme Court struck it down. Justice Chandrachud wrote, democracy is part of the basic structure. Parliament cannot destroy democracy by putting the Prime Minister's election beyond judicial scrutiny. The court had spoken. Even the most powerful office in India could not escape the Constitution. Case 6 is ADM Jabalpur of 1976. But then came India's darkest constitutional hour. During the emergency, fundamental rights were suspended. Citizens detained without trial filed petitions. The question in ADM Jabalpur versus Shivkant Shukla was, do citizens have any remedy when fundamental rights are suspended? The majority, Justice A.N. Ray, Beg, Chandrachud and Bhagwati said no. They held that during emergency even the right to life could be suspended. Justice Beg even remarked, quote, even if life is taken away, comma, no remedy lies, unquote. But one man stood alone, Justice H.R. Khanna. In his immortal dissent, he declared, even in the absence of Article 21, the state has no power to deprive a person of life or liberty without authority of law. Without liberty, law loses its meaning. Without law, liberty loses its value. That dissent cost him the Chief Justiceship, but it gave him immortality. It also showed that judiciary too could fail, and sometimes only one voice stands against tyranny. Case 7 is Minerva Mills of 1980. When the emergency ended, Parliament tried again to assert supremacy. Through the 42nd Amendment, It declared that Parliament's amending power was unlimited. But in Minerva Mills versus Union of India, the Supreme Court struck it down. Justice Bhagwati wrote, limited amending powers is itself a basic feature. Parliament cannot convert a limited power into a unlimited one. The pendulum had swung back. Judiciary reaffirmed its supremacy as guardian. Case 8 is NJAC 2015 case. Fast forward to recent times, Parliament unanimously passed the 99th Amendment, creating the National Judicial Appointments Commission, giving Parliament and Executive a role in judge appointment. But in Supreme Court, Advocates on Record Association versus Union of India 2015, known as NJAC case, a 4:1 majority struck it down. Justice J.S. Kehar wrote, quote, judicial primacy in appointments is part of the independence of the judiciary, which is part of the basic structure, unquote. But Justice Chilameshwar in dissent warned, quote, transparency is the best disinfectant. Collegial system lacks transparency. There can be no republic without accountability, unquote. This was another movement of collision. Parliament claimed to reform judiciary, claimed to protect independence. The people stood puzzled who truly spoke for them. So what is the thread of all crises? Let's look at this pattern. Shankari Prasad, Parliament Supreme. Golaknath, Judiciary Supreme. Kesavananda, Constitution Supreme. Indira Gandhi, democracy itself on trial. ADM Jabalpur, judiciary failed but one dissent saved hope. Minerva Mills, Parliament limited. NJAC, judiciary struck Parliament down. Every crisis told us one truth. The battle between Parliament and judiciary is not temporary, it is structural, it is eternal. As long as numbers claim legitimacy and principles claim supremacy, there will be a conflict. But conflict is not collapse. Conflict is the dialogue of democracy itself. Now, having seen the greatest crisis, we must analyze the meaning. What do these cases tell us about the balance of power? What philosophy emerges from these battles? This is where we turn next. Part 4 is about case law analysis. One is Ambedkar's anchor. Constitution as a living document. Let us begin not with a judgment, but with the man who framed the philosophy. We are Ambedkar. In the Constituent Assembly, made two statements that still echo in every judgment. First, it is sure to turn out bad. However, bad a constitution may be, it may turn out to be good if those who are called to work it happen to be a good lot. Second is, the Constitution is not mere a lawyer's document. It is a vehicle of life, unquote. These lines gave Indian judges license to interpret boldly. Ambedkar planted the seed of what later became judicial activism. The belief that the Constitution must evolve, must protect life, must restrain raw political power. Second, Justice H.R. Khanna, liberty beyond articles. In ADM Jabalpur, when every other judge surrendered to the state, Khanna stood alone. His reasoning is worth savoring slowly. He said, even in the absence of Article 21, the state has no power to deprive a person of his life or liberty without the authority of law, unquote. What does that mean? It means liberty is not gifted by the Constitution. Liberty is a natural right, pre-existing, inalienable. The Constitution only recognizes it, not creates it. This was radical. Most judges see the Constitution as a source of lights. Khanna flipped it. The Constitution is merely the shield, not the source. The source is human dignity itself. This is why Khanna's dissent is greater than the majority judgment. It placed the soul above the statue. Third, Justice Y.V. Chandrachud from submission to supremacy. Chandrachud's career is a story in contrast. In ADM Jabalpur, he joined the majority, denying rights during emergency. But later, as Chief Justice, he authored Minerva Mills, striking down Parliament's attempt to claim unlimited power. In Minerva Mills, he wrote, quote, limited amending power is itself a basic feature. Parliament cannot convert a limited power into an unlimited one, unquote. The shift is telling. It shows that judges evolve with crisis. The same Chandrachud who once bent to the state later drew the hardest line against Parliament. And perhaps the lesson is this. Judicial philosophy is not born in theory, but in trial. Judges discover themselves in the furnace of history. 4. Justice P.N. Bhagwati, the activist architect. Bhagwati too carries contradictions. In ADM Jabalpur, he failed the test, joining the majority. Years later, he admitted, "It was the biggest mistake of my life." But it was Bhagwati who later created the entire edifice of public interest litigation and expanded Article 21 into a fountain of rights. In Indira Gandhi vs. Union of India, 1978, he wrote, "The principle of reasonableness, which legally as well as philosophically is an essential element of equality or non-arbitrariness, pervades Article 14 like a brooding omnipresence." With those words, Bhagwati transformed the constitution. Article 21, life and liberty, Article 14, equality, and Article 19, freedoms, became a golden triangle. No law could violate this triangle, but Bhagwati failed in crisis, but redeemed himself in creativity. He showed that even fallible judges can leave immortal legacies. Fifth, Justice J.S. Keher versus Justice Chandrachud, the NJAC split. The NJAC case is modern proof that the Parliament Judiciary battle never ends. Justice Keher struck down NJAC, holding judicial primacy in appointments as part of the basic structure. He wrote, "Independence of judiciary is an integral part of basic structure. If the judiciary has to guard the constitution, it cannot be left to the mercy of the legislature and the executive." But Justice Chandrachud dissented. His words cut sharply. Transparency is vital principle of constitutional governance. Collegium system lacks transparency. Judges appointing judges is unethical to accountability. Here we see two visions. Keher feared capture. Chandrachud feared judicial opacity. Both were right in part. But the case exposes the paradox. The judiciary protects itself in the name of independence, even at the cost of democratic participation. Sixth is Justice Khanna versus majoritarianism, the Kesavananda vote. In Kesavananda, it was Khanna again who carried the decisive vote. He said, "The power of amendment is wide but not unlimited. It does not include the power to destroy." Notice the philosophy. He did not say Parliament cannot amend. He said Parliament cannot destroy. That single distinction saved Indian democracy. Because without it, either Parliament would have been supreme, Shankari Prasad model, or judiciary would have frozen the constitution, Golaknath model. Instead, Khanna offered a middle path, growth, but the guardrails. That reasoning is why India survived authoritarian temptation. If we weave together these voices, Ambedkar, Khanna, Chandrachud, Bhagwati, Keher, Chandrachud, what emerges? Ambedkar gave us the idea that the constitution is alive. Khanna gave us the truth that liberty is above the constitution. Chandrachud showed that judges can learn from failure. Bhagwati proved that creativity can redeem weakness. Keher defended independence with rigidity. Chandrachud defended accountability with courage. This is the symphony of Indian constitutionalism, discordant, contradictory yet enduring. And that is a mark of living democracy, not perfection, but perpetual struggle. So when we are studying these cases, we are not studying law, we are studying philosophy in battle. Judges as human beings and India as an unfinished experiment. The judiciary does not always get it right. Parliament does not always act in good faith, but between them, in their conflict, the constitution breathes. And that, my friends, is why case law is not mere precedent. It is the diary of our democracy. Let's discuss part 5, political responses when Parliament strikes back. We have seen how the judiciary built its role, case by case, judgment by judgment, but no story of constitutional power is complete without the counterpoint for every judgment. There has been a rebuttal for every assertion of judicial guardianship. There has been a political voice, loud, sometimes defiant, sometimes resentful. And if the judiciary asks, who gave Parliament authority to amend everything? Parliament asked back, who gave you the authority to veto the will of people? 1. Indira Gandhi and the language of supremacy. Let us begin with the most famous political declaration in this battle. Indira Gandhi, in the heat of constitutional confrontation, declared in Parliament, "Parliament is supreme, it represents the will of the people." Unquote. These were not casual words, they were strategic. They came at a time when the Supreme Court had begun striking down constitutional amendments, calling the idea that Parliament's power was unlimited, challenging it. To Indira Gandhi, this was more than legal semantics. It was a political weapon. By claiming supremacy for Parliament, She was cloaking her government's authority in the mantle of democracy itself. And after all, her reasoning was simple. Parliament is elected. Judges are not. Parliament reflects the majority. Judges reflect no constituency. So how can unelected judges overrule the representatives of the people? Let's pause here. Her claim reveals a tension at the very heart of democracy. Is democracy just majority rule, or is it majority rule restrained by constitutional principles? Indira Gandhi believed in the first. The Supreme Court in Kesavananda Bharati and later in Minerva Mills argued for the second. Her words remain a rallying cry for every elected representative who feels judicial review is an intrusion into the political domain. 2. Law Commission reports. The institutional warnings. This tension did not vanish after the emergency. Decades later, even neutral bodies like the Law Commission of India echoed concerns about judicial overreach. The 170th report of the Law Commission, for instance, noted that while judicial review is essential, courts must avoid crossing into areas of policy making which are within the exclusive domain of legislature and executive. The Commission's caution was clear. Judges exist to interpret law, not to govern the country. When courts issue directives on what to eat for school lunches, how to burst firecrackers, or when to ban diesel vehicles, critics say this is not interpretation, it is administration. And the Law Commission feared something dangerous. If courts overstep too often, they risk eroding their own legitimacy. The judiciary's power lies in public trust. If that trust turns to resentment, even good judgments can lose their force. Arun Jaitley's quip, brick by brick. Fast forward to 2015, the NJAC judgment had just struck down the constitutional amendment that created a new system for appointing judges. Parliament had unanimously passed the amendment. 20 states had ratified it. It was one of the most broadly supported reforms in recent times. And yet, the Supreme Court declared it unconstitutional. The political backlash was sharp. Arun Jaitley, then finance minister, delivered a line that cut to the bone. Quote, step by step, brick by brick, the edifice of India's legislature is being destroyed. Unquote. This was not merely rhetoric. It captured the frustration of elected representatives who felt sidelined. To them, the court had not only overturned their work, it had humiliated the democracy process itself. Imagine their view. When 500 members of parliament and 20 state legislatures speak with one voice and 5 judges silence that voice, who really governs? Jaitley's word crystallized a sentiment. Judicial activism, once celebrated, was now seen by many in political circle as judicial encroachment. 4. The broader resentment of elected representatives. Let us widen the lens. Across party lines, politicians have often voiced resentment against what they see as judicial activism. Why? Because judicial review can appear to politicians as a veto on democracy. Every law struck down, every scheme halted, every directive written by the courts feels to them like a direct slap at their electoral mandate. Consider 3 strands of this resentment. First, the democratic argument. Elected representatives believe they alone embody the people's will. They face elections, public scrutiny, accountability. Judges do not. Second, the institutional argument. Politicians argue that judges are not trained administrators. They lack resources, data, and the machinery to implement policies. So when courts dictate environmental, economic, or educational policy, the results may be idealistic but unworkable. Third, the sovereignty argument. For many politicians, judicial review feels like a foreign transplant, an American idea superimposed on India's parliamentary democracy. They see it as distorting the Indian model, where parliament was supposed to be central. This resentment does not always mean hostility. Often it is a demand for balance, but it reveals the deep unease that simmers whenever courts intervene too aggressively in governance. 5. The irony of the political pushback. Yet, here lies an irony worth noting. The same politicians who resent judicial intervention often rush to courts when in opposition. The same leaders who denounce judicial activism when they hold power applaud judicial courage when they do not. This duality shows us something important. The tension between parliament and judiciary is not a partisan fight. It is structural. It is baked into the DNA of the constitution. And that is why these political responses matter. They are not simply about egos or party politics, they are about defining the boundaries of power in a republic. So we see the picture. Indira Gandhi's cry of supremacy, law commissions, sober warnings, Arun Jaitley's sharp-picked brick-by-brick lament, and the continuing resentment of politicians who feel caged by judicial review. The courtroom and the legislature are not just two buildings in Delhi. They are two philosophies of power, and when they clash, the sparks shape the future of India's democracy. Now let's discuss the philosophical tug-of-war. Ladies and gentlemen, we now arrive at the heart of the trial. For 72 years, two institutions, Parliament and Judiciary, have wrestled over the soul of the Republic. Parliament claims to be the voice of the people. Judiciary claims to be the guardian of the Constitution. The clash is eternal. The stakes, democracy itself. Let us peel back the layers. 1. The Constitution supremacy. Chandrachud's warning. In Kesavananda Bharati 1973, Justice Y.V. Chandrachud spoke words that settled the foundation. Our constitution does not envisage, but the constitution itself to be supreme. Think about that carefully. Parliament is not supreme, judiciary is not supreme, but who interprets the constitution? The judiciary. This creates a paradox. The constitution is above all, but in practice, the judges decide what it means, and in that interpretive power lies the real sovereignty. 2. Limiting the legislature, Bhagwati's doctrine. In Minerva Mills 1980, Justice P.N. Bhagwati drew the line. Limited amending powers is itself a basic feature of the Constitution. This meant Parliament cannot claim absolute sovereignty. It cannot say, we are elected, therefore we can do anything. Even the power to amend is chained by basic structure. What this does is extraordinary. It makes unelected judges the ultimate referees of people's representatives. Judicial review, once a modest shield, becomes a sword. The message: Parliament is powerful but never omnipotent. 3. The dissent of Chelameshwar, accountability above all. But let us jump into 2015, the NJAC case. Here, Justice J. Chelameshwar delivered a dissent that was more than a legal note. It was a philosophical cry. He said, there can be no republic without accountability. His critique was surgical. Judges appointing judges behind closed doors, without transparency, without explanation. Was this democracy? He did not deny judicial independence. He denied judicial monopoly. This dissent reminds us, if Parliament is checked, so must be judiciary. Guardianship without accountability is just another form of supremacy. 4. Judiciary as guardian. The cases that saved rights. Now let us not forget the judiciary's highest moments. There are times it rose above politics and became the shield of the voiceless. Right to privacy 2017 Puttuswamy case. The court unanimously declared privacy a fundamental right. Justice D.Y. Chandrachud wrote, the right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21. This was not just about Aadhaar or surveillance. It was about dignity, identity, autonomy. The individual standing against the state. Vishaka Guidelines 1997 case, when Parliament had no law on sexual harassment at the workplace. The court stepped in. It laid down binding guidelines, treating international conventions as a part of domestic law. Here, the court became a temporary legislator, filling a vacuum Parliament left unaddressed. Next is environmental jurisprudence from Ganga pollution to the mining bans. The Supreme Court declared the right to a clean environment as a part of Article 21. It created the polluter pays principle, monitoring committees and continuous mandamus. Here again, the court acted as a policymaker. These are the moments where the judiciary became the moral guardian, acting when Parliament was silent, indifferent or compromised. 5th, judiciary as policymaker, the thin line. But here lies the tension. What does guardianship turn into governance? When does judicial activity cross into judicial overreach? Consider this: in Vishaka, the court created law, good law, necessary law, but law nonetheless. In environmental cases, it sometimes micromanages policies, deciding when mining opens, when industry is shut. In PILs, it has directed school lunch menus, traffic rules, even bans on firecrackers. Each of these may be justified in isolation, but taken together, they suggest a judiciary that sometimes behaves less like a court, more like a cabinet. The irony: The same judges who struck down Parliament's excesses sometimes themselves exceed judicial boundaries. So the core question, return to the fundamental question, Parliament versus Judiciary, who speaks for the people? Parliament says we are elected, we represent the will of people. Judiciary says we protect the constitution, which protects the people from tyranny, even of their representatives. Neither is entirely right. If Parliament alone ruled, rights would be hostage to majorities. If judiciary alone ruled, democracy would be hostage to unelected elites. The truth is, republic needs both. Parliament as a voice, judiciary as a conscience. One to speak, one to restrain. And that, my friends, is the heart of tug-of-war. It is not a battle of egos, it is balancing act. Messy, imperfect, sometimes frustrating, but essential. For in that struggle lies the survival of our democracy. If one wins absolutely, the republic loses. It is in the tension, the push and the pull that liberty breathes. Now let's walk into the part 6, the future, guardian or super sovereign. This section is about projection and vision. AI, surveillance, populism, judicial reforms, constitutional morality in the 21st century. It should cement your position as a constitutional. And now we step beyond history, beyond philosophy, beyond crises and responses. We must ask, what is the future of this great tug-of-war between Parliament and Judiciary? Will the courts remain the guardians of our liberty, or will they, by slow steps, become a super sovereign that rules where legislatures fear to tread? The answer is not written yet. It will be shaped by technology, by politics, by the courage of institutions, and yes, by the choices we as citizens make. 1. The new battlefield, technology and surveillance. The old fights were about land reforms, emergency powers, constitutional amendments. The new fights will be about data, privacy, algorithms and artificial intelligence. The right to privacy Puttaswamy judgment of 2017 was only the beginning. That court recognized privacy as intrinsic to dignity. But privacy today is not just about tapping telephones. It is about biometric database, facial recognition, predictive policing. Parliament is already arming the state with surveillance tools. The Digital Personal Data Protection Act, the expansion of Aadhaar, proposals for centralized databases all claim efficiency but risk intrusion. Here the judiciary may be forced to play referee. When the state says national security requires total surveillance, will the court whisper back? But liberty requires restraint. The future, my friends, will not be Indira Gandhi or H.R. Khanna. It will be artificial intelligence versus Article 21. And the court will be asked, where do we draw the line? 2. Populism and the judiciary's dilemma. Let us talk about populism. Across the world, strong leaders have risen. From Trump in America to Erdogan in Turkey to Orban in Hungary. They command majorities, they rewrite rules, they demand loyalty. India is not insulated. Our politics too have seen waves of populism. Leaders who say, I alone represent the people. When such leaders govern, they often clash with courts. Why? Because courts are slow, cautious, bound by precedent. Populism is impatient, emotional, majoritarian. The judiciary then faces a dilemma. Resist too much and you risk being branded anti-people. Resist too little and you risk becoming irrelevant. Ambedkar foresaw this. He said, in politics, bhakti or hero worship is a sure road to degradation and to eventual dictatorship. The challenge for the judiciary in the age of populism is to resist hero worshipping, to stand firm as an institution when all around it individuals rise and fall. Third, the question of judicial accountability. But here lies a deeper problem. The judiciary itself is not about scrutiny. Remember, Justice Chandrachud's dissent in NJAC case. There can be no republic without accountability. This remains the unhealed wound. Judges appoint judges. The process is opaque. The collegium operates in secrecy. Parliament tried to reform it through the NJAC with near unanimous support. The court struck it down, but the resentment lingers. Can the judiciary continue to claim legitimacy while resisting reforms that would make it more transparent? Can a guardian who demands accountability from all others refuse to accept accountability for itself? The future will demand an answer, either through self-reform or through political confrontation. 4. Jurisprudence. Let us look at another frontier, environment and social justice. Courts in India have expanded Article 21 into a living charter: the right to education, the right to livelihood, the right to a clean environment. These interventions have changed lives. They have forced governments to act where legislature hesitated. But can the judiciary continue down this path without overburdening itself? When judges become policymakers, they risk spreading too thin, monitoring mining leases, traffic plans, school meals. The danger is not overreach, it is underperformance in their primary role, delivering timely justice. Lakhs of cases still wait, years of lives are lost in delay. If the judiciary spends its time writing policy, who will clear the docket of the common citizen? The future demands a balance. Judicial activism must not come at the cost of judicial efficiency. 5th, Parliament's counter moves. Do not forget, Parliament is not passive. It has tools. It can pass amendments, restructure jurisdictions, even limit the scope of judicial review, as long as it does not touch the basic doctrine. Political resentment against the judiciary has not vanished. It simmers. Arun Jaitley's warning, step by step, brick by brick, the edifice of India's legislature is being destroyed, was not the last word. The question is, will Parliament accept the judiciary's role as guardian? Or will it one day push back with an amendment that triggers another Kesavananda movement? History tells us such confrontations are never permanently resolved. They are suspended, waiting for the next crisis. 6th, the future balance, guardian or super sovereign. So where are we headed? If the judiciary continues to expand privacy, environment, social justice, governance, it risks drifting into super sovereignty. If Parliament claims aggressively, it risks weakening fundamental rights and constitutional guarantees. The truth is, neither extreme will sustain democracy. The Republic needs a judiciary that is strong enough to resist tyranny, but humble enough to respect elected authority. It needs a parliament that is assertive enough to legislate boldly, but restrained enough to respect constitutional limits. The future therefore lies in balance, in dialogue, in tension, yes, but creative tension, not destructive war. As Justice Bharati once reminded us, the rule of law is the foundation of a democratic society. If the judiciary, the rule of law will fail and democracy will be in peril. But as Ambedkar warned, parliamentary democracy requires not only legal forms, but the spirit of equality and fraternity. The balance is fragile, but it is all we have. So my friends, when we ask the question, Parliament versus Judiciary, who speaks for the people, the answer may be uncomfortable. Neither speaks for the people fully. Both speak partially. Parliament speaks with the voice of numbers. Judiciary speaks with the voice of principles. And the people, the true sovereign, must listen to both. The judiciary must guard liberty. Parliament must embody democracy. Together in tension, they must preserve the republic. The danger is not in their clash. The danger is in one challenging the other. If Parliament becomes supreme, liberty may vanish. If judiciary becomes supreme, democracy may weaken. The future lies in balance, in that fragile dance between numbers and principles, between the will of the majority and the conscience of the constitution. And that, my friends, is the destiny of India's democracy. Now we have walked through history, from Shankari Prasad to Kesavananda Bharati, from Indira Gandhi's emergency to the NJAC debates. We have listened to the voices of Ambedkar, Bhagwati, Chandrachud, Chilameshwar. We have felt the weight of critics, the crisis, the pull of philosophy, the friction of politics. And yet, the answer remains deliberately unresolved. Because the truth is this, in a democracy, no single institution can claim a monopoly over the people's voice. Parliament reflects the pulse of the majority. Judiciary reflects the conscience of the constitution. One without other is incomplete. The health of our republic depends on their constant dialogue, sometimes sharp, sometimes creative, sometimes even confrontational, but always within the framework of the constitution. Ambedkar, in his wisdom, gave us a document where no authority is absolute, no institution unchecked. And Justice Chandrachud reminded us in Kesavananda that it is not parliament, not judiciary, but the constitution itself that is supreme. The real sovereign, however, is not either of them. It is us, the people. We are the ultimate judges of whether our freedoms live or die. We are the sentinels of whether democracy flourishes or fades. So the question is not just who speaks for the people. The question is, are we, the people, still listening? Are we vigilant enough to guard liberty? Thoughtful enough to demand accountability? Wise enough to protect both democracy and dignity? That is the responsibility Ambedkar placed in our hands. That is the unfinished project of our republic. And that, my friends, is where I leave you today. This has been The Next Hearing, and I am Amod Bidhuri. And together in every conversation we hold here, we're not just debating law, we are shaping the very destiny of Indian democracy. Until the next hearing, stay vigilant, stay questioning, and never forget, the Constitution lives as long as we do. Thank you.